Hello students, today here we are to discuss about certain important topics for mains 2023 from the Polity section, current affairs. This would be a series of videos where we'll be discussing potential topics for the upcoming mains. So today we are starting with the topic Office of Governor. So the Office of Governor. Let's first see which articles of the Indian Constitution talks about the Office of Governor. That is Article 153 to Article 163 of Indian Constitution talk about the Office of Governor. Of late we have been seeing many news where the Office of Governor's role has become very controversial. Let's see why it has become controversial. Recently many states such as Tamil Nadu, West Bengal, Jharkhand, there is a tussle between Chief Minister of the state and Governor. So when it comes to Tamil Nadu, recently we have seen that Governor of Tamil Nadu has refused to read certain parts of the Governor's address. Tamil Nadu Governor refused to read certain parts of Governor's address in the State Assembly, stating that he would prefer not reading those parts, but he himself added certain points from his end. So this is kind of violation of Constitution. And when it comes to State of West Bengal, there is a constant tussle between Chief Minister of West Bengal as well as the Governor. So here in the state of West Bengal, the tussle went to the extent where state legislature has passed a bill saying that the Chancellor of State of University should be, Governor should be replaced and the CM should be made the Chancellor. Actually, what we read is Chancellor of the State is usually Governor of the State. The tussle went to the extent where CM is being given the post of Chancellor of the State. And when it comes to Jharkhand, recently the Chief Minister of Jharkhand has been alleged of multiple allegations. When the Election Commission of India has advised the Governor of Jharkhand to remove the Chief Minister or to take the action against the Chief Minister was not being removed by the Governor. So all these instances shows only one thing, that the role is becoming more and more controversial day by day. So now let's see what are the problems associated with the Office of Governor. So it all starts from the appointment of the Governor itself, because there are no criteria for the appointment and the states are not being consulted, because the post of Governor itself is a selected post, not an elected post. And when it is selected, the central government unilaterally selects the Governor and there is no consultation with states. And it has become a resting place for bureaucrats and loyal retired bureaucrats and loyal retired politicians. So this is the first issue, that is appointment of the Governor and appointment and dismissal of the Chief Minister. Recently we have seen that in 2018 hung assembly elections in Karnataka. What is the usual convention? The largest party is invited to form the government. But because the largest party the largest party is not the ruling party, the Governor has not invited the party to form the government. This again is a controversial statement. Reservation of bills for consideration of President, that is Article 200. There is no time limit in which the Governor should give the assent to the bill. This is the problem again. And misuse of Article 356. President rule, almost every state in this country has been subjected to President rule unilaterally by the center, kind of disrupting the federal structure of this country. And removal of the Governor, again, appointment is a problem, removal is again a problem, because there is no fixed tenure, no fixed term, and no specific grounds for the removal of Governor. So, appointment is an issue, appointment and dismissal of Chief Minister is an issue, removal of Governor is an issue, and misuse of Article 356 and reservation of bills. These are the issues associated with Office of Governor. Now let's talk about certain Supreme Court judgments. The first judgment, Shamsher Singh versus State of Punjab. In this judgment, Supreme Court said that the discretionary powers are not beyond the state legislature. Discretionary powers of Governor are well under the control of state legislature, and the Governor is bound to act with aid and advice of Council of Ministers. He is not bound, he is not supposed to act in his discretion. And S.R. Bommai versus Union of India, Supreme Court said that it is not the subjective assessment of the Governor to decide if the government of the day is in the majority or not. For that to be proven, floor tests need to be conducted, and without floor test, mere assessment or subjective assessment of the governor cannot be taken into consideration. And the third case is Nabam Rabia versus Deputy Speaker. In this case, again, this has been reiterated that governor does not enjoy discretionary powers. It is always subject to constitutional standards. And Article 174 says the same again, that within the advice of Council of Ministers headed by Chief Minister, governor is supposed to act. So we've seen the problems. Now let's talk about the recommendations of various committees. What have various committees recommended to reform the role of governor? So the first ARC says that he should be a non-partisan person who is not involved in politics, who is not very prominent with recent time politics, but has a long experience in public life and administration, and particularly non-partisan persons. Sarkaria Commission has given recommendations at a length from appointment of governor to removal of governor and use of Article 356. When it comes to the appointment of governor, he should be appointed after consultation with Chief Minister of the state. Again, this is just a recommendation, it's not binding, but it would be wise to follow this. Again, the governor should be eminent in some walk of life from outside the state. Outside the state again, eminent in some walk of the life, and detached figure without intense political links. Repeating the same thing again by first ARC. And this is about the appointment. When it comes to removal of the governor, he should be, if at all he is being removed before the term ends, that is 5 years, only if the doubts are raised about his morality, dignity, constitutional propriety. Unless the doubts on these three issues have not been raised, the governor is not supposed to be removed on arbitrary grounds. And in the process of removal, before the end of the term, state government may be informed and consulted. Again, strengthening federalism here. And when it comes to reforms in Article 356 usage, it is to be used very sparingly as a matter of last resort and only in cases of political crisis, internal subvention, physical breakdown, etc. So these are the recommendations of Sarkaria Commission only for appointment, removal and usage of 356 article. And NCRWC has given recommendations again, saying that there should be a committee formed with Prime Minister, Home Minister, Speaker of Lok Sabha, along with the Chief Minister to decide whom should be appointed as the governor of the state. Now coming to suggestions by second ARC, again, Interstate Council under Article 263 has to come up with guidelines for governors when they are using their discretionary powers. And again, Punchi Commission says the same, that governors need to have a fixed term of 5 years. There should be a specific impeachment process. We all know that there is no impeachment process specifically for governors. We have impeachment for president, and this is the reason why the governors are arbitrarily being removed in this country. So, doctrine of pleasure for governors should be removed. So, these are the recommendations by Punchi Commission. So, yeah, out of all these recommendations, the most important one is Sarkaria Commission and NCRWC, Punchi Commission. This also needs to be written, but relatively these three should definitely be written. And yeah, so what are we supposed to do to reform the office of governor? First thing, we have multiple commissions and multiple recommendations as we have read till now. So we have to implement particularly the recommendations of Sarkaria and Punchi Commission recommendations for the appointment and removal of governors. That is the first solution. And the second solution, again, Punchi and Sarkaria commissions have recommended that governors should not be burdened with the positions and powers. This indirectly is talking about the post of chancellor, that were beyond the constitutional domain. Both the commissions agreed that this would be in the best interest of the state. And third suggestion is, governor should act as a balancing wheel of federalism between center and state, not as an agent of center. So the governor should not act as the agent of the political party in power at the center. Governor should act as a link between center and union government. And the fourth one is, governor's discretion and constitutional mandate should be codified under code of conduct. It's not, discretion cannot be any discretion. So it needs to be codified and motivated by good faith, temperated by caution. And the fifth and the final suggestion is, again, codification of discretionary powers also should include the time frame within which they must act, and stating unequivocally that they are required to follow the advice of cabinet when dealing with bills. So the codification should include what is the time frame within which the governor should act on the bill, as well as following the advice of cabinet when dealing with the bills. So this is about the governor. Thank you.